Following the announcement that Michael Morrissey will not be seeking re-election, that officially makes him eligible for the Fervent Hall of Corruption class of 2026. And it's no surprise he has emerged as the favorite to take home the prestigious Golden Taillight Award for biggest piece of shit. Let's see why he's such a favorite by looking at this highlight reel. Miss Gilman, if you could. Now, this is his masterpiece. Just a wonderful piece of corruption here. A tape that will be studied by future corrupt leaders nationwide. About 14 ethical violations in this 5-minute video alone. Hall of Fame numbers. Sprinkle in about a handful of provable lies, and you have the chef's kiss, of impropriety. The first trial ends in a mistrial. Shout out Judge Cannoni for not polling the jury nor accepting a partial verdict. Great corruption on her part. Now, what an ethical DA would do is perhaps realize that they didn't have the evidence to convict and just cut their losses and move on. But not my Mikey. He decides to shell out more taxpayer dollars to bring in a ringer. And not just any ringer. Let's bring in the guy that defended Whitey Bulger. That'll make the community trust his prosecution even more. And now we get to the worst of them all. A young woman, a woman who is part of the Police Explorers program, is found dead in a Canton apartment. And all you have is the footage of the potential culprit entering the facility minutes before the incident and leaving the facility minutes after the incident, plus 32,000 text messages showing the nefarious relationship between them, the FBI conducting its own investigation, and handing you a case on a silver platter. And what did you do with that silver platter? You sent it back to the chef. Oh, you want to implicate a cop? Not on Meatball's watch. Good morning, bonjour, bon dia, buenos dias. Hello to everyone. It's another Fervent Saturday, finally getting a little warmer here in the U.S. corruption capital. Speaking of corruption, we are here to talk about two cases that are chock full of it. I've been meaning to get around to the Sandra Birchmore case. It's an important case, but it's a heavy, tragic case, as you know, and the latest motion filed in that case really illustrates that. But since our sort of bedrock case on this channel is Karen Reed, what we're going to do is make the connection through splicing together testimony, interviews, and statements to bridge the gap between these two incidents, which happened a year apart. Obviously, they happened in the same county. There are a few players who are involved in both cases, notably the district attorney, Michael Meatball Morrissey. Our shout out of the day goes to a small channel called Brother Counsel. He's probably on cloud nine because, he's been floundering in the minor leagues for a while. But we gave him the old Fervent bump in our last video, and now I think he's really ready to make an impact on the main stage. I am kidding, of course, you guys. Brother Counsel is a phenomenal YouTuber and one of my favorite in the space for a long time, so it was really cool to see him give us that shout out. If you're some weird alien that is somehow subscribed to me and not Brother Counsel, go over, subscribe to BC. I am also a big fan of Brother Solomon, who shares a startling resemblance to Paul Dano's The Riddler in the latest Batman. I've always wanted to point that out. I know the motto here. You know the motto here. But like, but comment, but subscribe. I'll see you all on the other side.
Yeah, I was curious because I didn't know how much of it would be, okay, what's going on in Norfolk County, and how much of it might be, okay, what's going on as a federal prosecutor.
No,
right?
and I for me, it was what was going on here in Norfolk County. And in fact, at the time, I was living in Boston, right, which is not part of Norfolk County.
Yeah.
And it was significant enough that I left my job. You can't run for office because of the Hatch Act as a federal employee. I sold my condo in Boston. I moved to Quincy to do this, and I'm running full time until this fall.
Because at the time that you declared your run, Morrissey had not yet declared that he wasn't running, but it had also been a long time of crickets from him. Wasn't clear whether he was had any intention to run for re-election.
A lot has been made of you personally, obviously, over the last couple of years. We haven't really had a chance to hear from you. How have you been doing, and what does this say today?
Well, the good or bad news is, having been in office for a number of years in politics, unlike my time on Beacon Hill, I get to speak out. But many of you know that now as a district attorney, that if I speak out, that I interfere with an individual's right to a fair trial, then that obviously weighs heavily upon me. So I am now free to speak today on this trial with some limitations. And so not hearing from me, obviously, then I don't want to tip the jury or tip the scales and let those cases go forward without putting your thumb on the scales of justice. And you know, I took the job to speak for victims, and we focus on victims, and that's what I'm going to continue to do through my tenure. So this will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
Keep walking. Just keep walking. Nobody wants you. Let's go, Green!
Still got everybody around you, right?
You do. Go be by yourself.
For how long?
You said that there was this statement that horrified you, your words, horrified you, that Carrie Roberts made during her interview, that you were eavesdropping on, right?
I'm not sure if she made it during that interview. I'd have to look back to see when I said she told them everything in bold, because I know she had said it to me multiple times. So I'm not sure if it's when she said it in the interview or just in general, when she said, I told them everything, I told them, etc.
And you said that horrified you, correct?
I didn't know Carrie Roberts, so yes, her statement horrified me.
Horrified you.
Yes, that was horrifying.
And in that group chat, your response to that horrifying statement was 3 words: I love it.
I met Elizabeth Proctor in approximately July or August of 2023. We are 2 mothers that are being viciously terrorized and harassed by social media. Things that were stated in this courtroom and allegations that were made have torn our lives upside down. I see a yes.
Ms. McCabe, the reason you deleted that 2:27 a.m. call is because you realized that if you were caught Googling how long it takes for a person to die in the cold 3.5 hours before John's body was found, that would incriminate you, wouldn't it?
Objection.
The objection sustained.
Did you delete that search because you knew that you would be implicated in John O'Keefe's death if that search was found on your phone?
Objection.
Could you answer that, please?
I did not delete that search. I never made that search at 2:23. I never would have left John O'Keefe out in the cold to die because he was my friend that I loved.
But he's not your family, is he?
Family and friends.
Is he
Objection.
not your...
Sustained.
You acknowledge that you made the search at 6:23, don't you?
In the morning I did, yes.
Acknowledge that you made the search at 6:24.
Multiple times in the morning, yes.
Of the 3 searches that show up that were all found on your phone, the one that you disavow is the one that took place at 2:27 a.m., which would implicate you and exonerate my client, correct?
Objection.
Sustained.
We are 2 mothers trying to get through the unthinkable together.
So you were upset about the public outrage concerning your family's involvement in the death of John O'Keefe.
I was outraged because I am a state witness that is being tortured because of lies.
Because of public outrage concerning your family's involvement in the death of a police officer, correct?
No, it's a social media witch hunt.
I see. So you decided that the best way for you to address that angst that you were feeling is to go to the lead investigator's home, personal home, in this case, correct?
I went to visit Elizabeth Proctor. Michael Proctor was not home.
But you do know that you started suffering this harassment that you claimed is awful and terrible, etc., around April of 2023. Is that right?
I didn't claim it's awful. It is awful.
Okay, I'm sure it is awful, Ms. McCabe. I'm sure it's terrible.
It is.
It sucks to be harassed.
It really does.
Yeah, I'm sure it does.
Objection, Your Honor.
You were upset by April of 2023 that there was public outrage about your family being involved in the death of John O'Keefe. That's what you were upset about, correct?
I was upset that we as witnesses were being harassed.
You were upset about public outrage concerning this case, correct?
Objection.
Sustained. That was answered. Next question.
And 2 months later, in June of 2023, for the first time, you testified at another proceeding, and lo and behold, you attributed the words, "I hit him," to my client, right?
Objection.
So ask that without the objectionable phrase.
2 months later, at another proceeding, in June of 2023, you attributed the statement, "I hit him," to my client for the first time under oath, correct?
Under oath, correct.
Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home.
So let's go down and look at what you had in your report for the area in white. In the area in white that you're referring to, there are 2 white circles, the largest one there. This, in fact, was a depiction that you included in your report on page 29, correct?
Correct.
Interesting and notable, you did not include that depiction in your timeline that you discussed with the jury yesterday, did you?
I did not know.
Circle around your house like my name Ian Whiffen.
But it was important enough for you to put that depiction in your report, correct?
Correct.
And notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
So, given your testimony on direct yesterday with Attorney Brennan, the phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
So, the next says, from the combination of device location and bearing, it does appear that the device started to move towards the house. However, since the bearing information appears to be based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. Did I read that correctly?
You did.
So the first part is again a statement that the device has started to move toward the house. But it is certainly possible that the device was at that location and was moving toward the house. That's possible, correct?
Based on location data, yes.
11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one.
But you will learn that there are big problems with the Commonwealth's theory of this case. You will learn that there were 6 people at that after-hours party at Brian Albert's house, all of whom left by the front door and would have been confronted by John O'Keefe's lifeless body on that lawn if he was actually there at that time. Those 6 people walked out the front door to 34 Fairview, walked to their cars, either in the driveway or parked in front of the house. Brian Albert's sister-in-law, Jennifer McCabe, was there. Her husband, Matthew McCabe, was there. ATF federal agent Brian Higgins was there, who was also Brian Albert's friend. Sarah Levinson, a friend of Brian Albert Jr., was there. Julie Nagel, another friend of Brian Albert Jr., was there. And Caitlin Albert, Brian Albert's daughter, was also there. All of them leaving the residence. Each of those people left 34 Fairview in Canton, where Brian Albert lived. Each of them walked out facing the front lawn, where the Commonwealth will tell you that a 6'2", nearly 220-pound big man in dark clothing was sprawled on the front lawn when there was only a dusting of white snow on the ground. He was supposedly sprawled on that lawn, just feet from where these people were walking when they left the residence. And you will learn that not one of these people saw John O'Keefe Lane. Not one.
So you'd agree that the visibility and lighting in front of the house was good enough that you were able to see tire tracks in the snow, correct?
Sure.
But you did not see a 220-pound man lying in the snow in your front yard, did you?
Objection.
Was that something that you saw, sir?
No, I didn't see that.
Against that white snow, did you see a black baseball cap?
I did not.
As you stepped out of the house, did you see a black sneaker?
I did not.
Did you see 45 pieces of red taillight plastic?
I did not.
No. Did you see one piece of red taillight plastic?
I did not.
Did you see a 6'2" man on your parents' front lawn in front of you?
Objection.
Did you? I did not.
And against that white snow, did you see a black baseball cap?
No.
Did you see a black sneaker?
No.
Did you see a 6'2", 220-pound man sprawled out right in front of you on that lawn?
No.
Did you see 45 pieces of red plastic?
No.
One piece of red plastic?
No.
So you saw nothing unusual on that front lawn as you walked out of that house, correct?
That's correct.
And when you looked out at that black SUV, and saw the V-shaped tire tracks, you did not see a 6'2" man lying on the front lawn, correct?
No, I did not.
Fair to say that walking out the front door of that house, you saw no body on that front lawn in front of you, correct?
When I walked out?
Correct.
No.
And as you drive by home, what, if anything, did you observe?
I did notice behind Sarah and Jen, I did notice something out of the ordinary, like a black blob in the ground by the flagpole.
You told investigators that when Brian Albert Jr. called you the next morning and you found out about the tragedy the previous night, you, quote, put 2 and 2 together, correct?
I did, yes.
And when you put 2 and 2 together, you did not call the Canton police, correct?
I did not know.
Did not call the state police, correct?
Nope.
Did not call the district attorney's office?
No.
You would agree with me that you just sat on this revelation, correct?
I would.
Objection, Your Honor.
Okay, that's sustained in that form.
And you were not interviewed by any investigator in January, February, March, or any time over the spring or summer of 2022, correct?
I don't remember the time frame, but not right after, no.
And when an investigator finally spoke to you, it was Michael Proctor, correct?
Correct.
He was the one who took your statement on October 12th of 2022, correct?
If that was the date and time, yes.
And that was over 8 months after you were driving past the Albert home at around 2 a.m. while you were drunk and supposedly seeing some black object, correct?
Before 2 a.m., yes.
And you know, Ms. Nagel, that as of October of 2022, the defense had, in this case, had publicly announced that
Objection, Your Honor.
that house saw
All
a body on that front lawn.
So that question's improper. I'm going to strike that question.
And after that SUV was gone, and you looked out that window with that clear and good view, there was no body, was there?
I never saw a body.
Thank you.
I wish I had.
Sounds like that's a little rehearsed.
Not at all. It's not at all.
I'll let the answer stand.
Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
Anybody else?
Not that I remember.
Sergeant Tully taking notes while you were having this conversation with Mr. Lally?
I do not remember.
Mr. Lally taking notes?
I do not remember.
Do you remember being told by either Sergeant Tully or Mr. Lally that your conversation was being recorded?
I do not remember.
When was the last time you did talk to Allie before she testified yesterday?
I don't remember.
Give me an idea. She's one of your best friends. A week ago, a day ago, a month ago.
I do not remember.
Could have been a year ago?
I do not remember.
Okay. Could have been 5 years ago.
No.
Okay. So it's more recently than 5 years ago that you spoke with Allie.
I don't remember.
So you have no independent recollection as you sit here. The last time you talked to one of your best friends and your cousin about any subject.
No, I don't remember.
Were you ever told in preparation for your testimony, if you start to get stumped or nervous, just say, I don't remember?
Nope.
Nobody ever told you that?
Mm-mm. No.
No?
No, sorry.
It's okay. So nobody ever informed you that you might get nervous on the witness stand, there might be tough questions. The easiest way to get out of that is just say, yeah, I don't recall.
No.
So you just don't recall because your memory is that bad. You literally don't recall the last time you spoke with a cop.
Objection.
Ask that differently, Mr. Jackson.
Sure. Your testimony is you are not instructed to say, I don't remember. You just literally don't remember.
Correct.
It's an issue with your memory, not an instruction that you received.
Correct.
Right. That you might see. Photographs, documents, videos.
Not that I remember.
He didn't show you the series of text messages between you and Miss McCabe, Allie?
I don't remember.
Okay, so you're not saying he didn't. You're just saying, again, you just don't remember.
Correct.
Okay. And this was just a month ago.
Around a month, correct.
Could have been sooner than a month. Or, let me ask that a different way. Could have been more recently than a month.
I don't know.
Don't know that either.
Mm-mm.
Is that no?
Yeah, no.
Who contacted you to come to the DA's office?
I do not remember that.
Don't remember that either?
No.
Other than on your phone when you made the screenshot, did you ever seen that before? Mr. Lally ever show it to you?
Not that I remember, no.
So you two didn't discuss that in your meeting a month or less ago?
We could have. I don't remember.
But again, you don't remember?
Mm-mm.
Is that no?
No.
Did Mr. Lally tell you why he wanted to question you about those text messages?
I don't remember.
Did you find that interview... By the way, how long did the interview last? Michael Proctor.
I do not remember.
Do you remember testifying at one point that it was about 10 minutes?
No.
But you do remember 2.5 years ago, you left 34 Fairview at 12:10 a.m., correct? Down to the minute.
Correct.
Got it.
Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. to have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them.
You then texted your wife, Brian Albert, and Nicole Albert, quote, "Tell them the guy never went in the house," correct?
Yeah, that's part of the same text. Yes.
Mr. McCabe, who was the guy that you were referring to? Does he have a name?
That would be John O'Keefe.
When you told the group to tell them the guy never went in the house, that was you talking about how you should all get your stories straight, correct?
No.
You would agree with me that your stories are all straight in terms of the guy never went in the house, correct?
Objection.
Can you answer that?
John never went in the house. It's not a story, it's a fact.
And in response to you saying the guy never went in the house, Brian Albert's response was, exactly, correct?
Yes, that's his response.
All right, we're done here.
The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you had doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion, that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never, in over 30 years of practice, have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence, and I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So, for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. The question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see your readings.
Issue this statement and give you a threat and give us a threat. He wants us to just shut up and quit. He wants you to shut up and quit. Quit with all the evidence, quit with all the motions, quit with all the arguments. Just go home and quit. Well, I have something to say directly to Mr. Morrissey right here, right now. So listen up, sir. And I'll speak slowly so you understand. Michael Morrissey, we ain't got no quit. Will not quit. And I can guarantee you, Karen Reed and her family will never, ever quit. Not until the John O'Keefe's killers are brought to justice.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
And what's Courtney Proctor's response?
Nothing. I just saw Julie, and she said when this is all over, she wants to get you a thank you gift. And I respond with, get Elizabeth one.
Hang on just a second. Let's take them one at a time. You were asked about this on direct examination by Mr. Lally, right?
Correct.
And you looked at the jurors, paused, and said, I never asked for a gift. I never received a gift. Elizabeth never asked for a gift. She never received a gift. You remember that?
Correct.
You said you never asked for a gift, correct?
Correct.
What's your next text?
Get Elizabeth one.
Get Elizabeth one what?
Referring to a gift.
Right. So you did, in fact, ask for a gift, didn't you?
For my wife, who had been home with my children for the last 10 nights.
From Julie Albert?
Yes.
For your participation on this case?
I don't know if that's yes.
Well, Courtney Proctor answers that question by saying, because I guess her and Chris were friends and John, and she's so proud of you for leading this investigation, correct?
Correct.
Trooper Proctor, after you knew that Canton Police Department was conflicted off the case, you continued to have a very close relationship with yet another Albert, Kevin Albert, correct?
We worked on a cold case together.
So you did have a close personal and professional relationship with Kevin Albert, didn't you?
I'd say it was a professional relationship.
Only a professional relationship?
Him and I were members at a gym together, and we worked a cold case together for several months.
Drinking, socializing maybe?
Once in a while.
Right. So it went beyond professional, right?
Yeah, acquaintances.
Drinking acquaintances, right?
On several occasions, yes.
Socializing acquaintances, right?
On several occasions.
So when you told the jury a few minutes ago that you were aware of and knew of but didn't have relationships with 3 Alberts, Julie, Chris, and Colin, not quite true, is it?
Objection.
Sustained.
There's a 4th Albert out there, isn't there? Kevin. Right?
Yes.
But you didn't tell us about that one.
Objection.
I'll allow it.
Correct?
I don't consider that a relationship. It's,
Well, let's look at that. 5 months into this investigation, in July of 2022, you were actually continuing to socialize with Kevin Albert, weren't you?
yes.
On July 19th, 2022, you and Kevin Albert went out drinking together, didn't you? Trooper Proctor, I'm not asking to look for anything in the binder at this point. I'm asking for your memory.
I don't recall that.
You don't recall the date, or you don't recall...
July 19th, 2022.
You don't recall the drinking?
The date itself, sir.
Why don't we turn to tab 13. In fact, the two of you got so drunk that Kevin Albert left his badge in your cruiser and couldn't find his gun the next morning, right?
Objection.
Overruled.
I can't speak to any level of intoxication, but I don't recall either of us being intoxicated.
Got it. So, isn't it true that on 7/20, July 20th, 2022, the day after, at 8:39 in the morning, you texted Kevin Albert, quote, "Found your badge in my cruiser this morning," end quote, correct?
Yes.
Then you texted him, "I can leave it in my locker at the gym, drop it off at your station, or leave it in my mailbox," correct?
Correct.
Kevin Albert responds, "My mailbox. Did I take my gun?" And then included a wince face emoji, correct?
Correct.
So the fact of the matter is, you two got so drunk that he couldn't find his badge and had to ask you the next morning where his gun was, right?
Again, I can't speak to any level of intoxication, whether he just forgot it, I don't
I'm
know.
not asking you about his BAC, Trooper Proctor. I'm asking, have you seen drunk people before?
Yes.
You've been drunk before.
Yes, I have, sir.
We've all been drunk before, right?
Yes.
Was he drunk? Were you drunk that night?
I don't recall. It was a long time ago.
But he left his badge in your cruiser after a night of drinking. Isn't that right?
Yes.
Which means you were drinking and driving in your cruiser. Right?
From what I remember, we were down the Cape working on the cold case together and stopped for dinner, had a few beers, and then dropped him off.
The next morning, Kevin Albert also texted you at page 2606. Starting with "It's bad." Tell me when you see that.
Okay, see it.
Kevin Albert responded, "It's bad!" Exclamation point, exclamation point. "I was hungover for sure today!" Exclamation point, exclamation point. "Couple tonight to make me feel good." End quote. Correct?
Correct.
And this is with Brian Albert's brother, Trooper Proctor.
Correct.
This should be seen for what it is, and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now.
And there were already 3 candidates in the race. Juna Perkins, Craig McClellan and Jim Bearcat. And so it made me wonder whether you had a reason to say to yourself, okay, A, what's going on in Norfolk County, but also, like, B, was there something about the candidates already in the race that made you say, well, I can't leave it in their hands to shape up Norfolk County's district attorney office?
Yeah, that's a great question. And obviously I didn't take the decision to do this lightly, given everything that it took to launch the campaign. I spent a lot of time looking at the race, and I came to the conclusion that for this job, in this moment, I happen to be uniquely qualified. I'm not a typical district attorney candidate. I am not a former state prosecutor. I'm not a current member of Michael Morrissey's leadership team. I'm not a career politician. I'm a former federal prosecutor. I specialize in public corruption cases. We can talk more about experiences I had before the U.S. Attorney's Office, but I've seen some of the hardest cases from both sides. And I've stood shoulder to shoulder with local, state, and federal law enforcement while standing up to entrenched institutions like the Massachusetts State Police. And particularly given some of the work that I was doing at the U.S. Attorney's Office, I realized my experiences were unique to this race. I think this is the rare political office in the rare election where having somebody who's actually an outsider should be a good thing. The fact that I didn't grow up in Norfolk County, though I grew up just across the southern border of Norfolk County, but the fact that I don't have those kinds of deep ties within the office, I think should be a good thing. The fact that my experience as a prosecutor was as a federal prosecutor, working in what I think is the most professionally run prosecutor's office in New England and one of the best in the country, having that experience, I think, uniquely situates me here, plus the fact that I've done corruption cases right here in Norfolk County. The through line of my candidacy is, or one of the through lines is rooting out corruption here. And ensuring that the public is confident in the DA's office, restoring faith and confidence in the office. So among other things, we're going to establish an anti-corruption task force, which would be a first of its kind task force in Massachusetts. Right now, corruption cases and allegations of corruption, whether that's police corruption or any other public official who's committing some kind of misconduct, the only entities investigating that really are the State Attorney General's office and the U.S. Attorney's Office. An anti-corruption task force, a dedicated team of folks led by a senior assistant district attorney in the office, will both provide an opportunity for law enforcement partners to refer cases to us and allow the public on a dedicated hotline to call in allegations of that kind of misconduct. And it'll also send a message to the public that we are not going to tolerate that kind of conduct here in Norfolk County. I could go on and on. It's a detailed set of priorities. I'm proud of it. And I'll come back to two-tiered system in a second because that is a through line in many cases in Norfolk County. If you know the right people, if you are connected to certain members of law enforcement, again, it's a small minority of members of law enforcement who are committing the kind of misconduct that I'm talking about. But if you know the right people, you get special privileges.
You're married to Matt McCabe, correct?
Yes.
Your sister is Nicole Albert.
Yes.
Nicole is married to Brian Albert.
Yes.
It was Brian Albert's home that you were at, 34 Fairview, that you arrived at where John's body was found, correct?
Yes.
The same home where that late night gathering was on January 28th going into the morning of the 29th, correct?
Yes.
Would you consider yourself to be close with your sister Nicole and Brian?
Yes, very close.
Your families, it's not just you and Nicole, your whole families are close, correct?
Yes, we have a very close family.
How long have you known Brian Albert?
Since I was in kindergarten.
You consider him, even though he is not blood related to you, you consider him family?
Yes.
In addition to Brian and Nicole Albert, you're also very close with Chris and Julie Albert, correct?
Yes.
Just to be clear, and I'm going to do this slowly, Brian Albert's younger brother is Chris Albert, correct?
Yes.
Chris Albert is married to Julie Albert.
Yes.
You consider Chris and Julie family even though there may not be a blood relation as well, correct?
Yes.
Chris Albert is a Canton Select Board member, is that right?
Now he is, yes.
And the Canton, that's in Canton? I said Select Board member, did I mention Canton Select Board member?
It is in Canton,
okay.
yes.
All right, obviously it's in Canton. The Canton Police Department reports to the Select Board, correct?
I'm not aware.
You're not aware of that echelon?
No.
Okay. You're aware that Brian Albert, your friend of, I'm not going to say how many years, but since kindergarten, was a Boston police officer.
Yes.
He had been a lifetime law enforcement officer for some 30 years before he retired recently, correct?
Yes.
He's a trained first responder, obviously.
Yes.
Brian Albert and Chris Albert have another brother named Kevin Albert, correct?
Yes.
Kevin Albert is a detective with a police department, correct?
Yes, I believe that's his title. I'm not 100%.
Which police department is Kevin Albert associated with?
Canton.
And you've grown up in Canton your whole life, you indicated?
Yes.
Your entire family has grown up in Canton, correct?
Yes.
It cannot be that if you know the right people or if you're in law enforcement and have certain relationships that you get a blind eye from the DA's office or other folks if there's a hint of involvement in an underlying crime. And we've seen a couple of high-profile cases, different high-profile cases, where one of the common themes is a question about what we do with law enforcement witnesses or potential law enforcement defendants. Obviously, I'm thinking of the death of Boston police officer John O'Keefe and the death of Sandra Birchmore. And I think while I can't comment on the details of the federal investigation in the Karen Reed case, what I can say is this. There were shortcuts taken and investigative missteps and decisions made by investigators and prosecutors in the DA's office in both of those cases that led to embarrassing controversies and victims who, to this date, have not gotten the justice they deserve.
Yeah. Now, you did work on, well, maybe not on the Karen Reed case in terms of her prosecution, but rather on investigating the DA office's conduct in that case, I understand. And presumably there's only so much you can comment on that, but my understanding is that you opened an investigation, you did some amount of investigating, and then that investigation was closed without any, additional prosecutions or anything of that nature.
You also indicated that you have never refused to speak to the police, any law enforcement officer in this case, correct?
I've spoken when but asked to, yes.
But in point of fact, when you were approached by the two law enforcement agents who were not connected to Massachusetts State Police or to Canton PD, you suspended that interview and refused to answer further questions, correct?
I welcomed them in my house, sat with them, and then I stopped, and then I met with them a few times after, and I answered all their questions that they asked. I helped clear up some misconceptions that they had been told, and as you know, I know they're no longer investigating, so I think I helped them well.
And you're obviously well aware that in that first interview, you stopped the interview cold and refused to answer further questions, correct?
I said I'm going to stop and I'm going to seek some counsel, yes.
Do I have that much correct? And is there any detail you want to add there?
So let me start with the Justice Department has a policy nationally not to confirm or deny the existence of investigations. This is a very unique case where it has been publicly reported that a federal investigation took place. It has been publicly reported that I was the lead assistant U.S. attorney on that case. And I can say this, the conduct that I observed as a public corruption prosecutor on cases I worked right here in Norfolk County directly led me to the decision to leave the U.S. Attorney's Office and run for district attorney. And I think no matter what you believe happened in the Karen Reed case, I think we can all agree, I hope we can all agree, that steps, and this is based exclusively on what is public, that steps taken and not taken by the state police investigators and the prosecutors at the DA's office did not meet the standard that the public deserves to expect from its DA's office and from its investigators. You and I are not trained investigators, but if you and I had encountered the crime scene on January 29th, 2022, there are things that you and I would have done, would have thought to do, that unfortunately were not done then. And, you know, I think, unfortunately, because of that conduct, because of the charging decision by the DA's office, again, based exclusively on what's in the public record, a charging decision that was not consistent with the evidence in the case, you had a controversy, to put it mildly, and a national and international law enforcement embarrassment that was broadcast across the country, on the internet, and elsewhere, that was not befitting the district attorney's office Norfolk County deserves.
You also didn't actually formally search the house, correct?
Absolutely correct.
We just talked about that. You didn't seek consent by Brian, pardon me, by Brian Albert to search the house, correct?
That's correct.
You also didn't seek a search warrant. You talked about that, correct? Correct. You don't get punished or in trouble if you seek a search warrant and a judge who has to sign the search warrant. Normal citizens can't do that. It requires a judge's signature. You don't get in trouble or get spanked or get slapped or get fined if you seek a search warrant and he's denied, correct?
In this particular situation, I would need to articulate facts, certain circumstances, and witness statements. What I had was nobody could put John O'Keefe in the house, including Miss Reed, and that we had a glass where they were coming from a bar, and I had 3 separate police officers, including myself, that had been in that house on 3 separate occasions and saw nothing amiss. I have a good faith obligation to present the truth to a judge, and if I don't, I can be found, end up on a Brady list or a Giglio list, as you know, and my right to my credibility to testify in my career is basically over. So yes, you can get in trouble.
You're talking about lying in an affidavit, sir.
I'm talking about misleading.
Correct.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that? Might that be of some concern to go inside the house and see if there was a struggle that started in the house?
There's still no evidence to go into the house.
You're a guy that's out on the lawn with no coat on. You think the coat might be inside the house? That might be a reasonable assumption? Yes or no?
No.
You got a guy outside with no shoe on. You think the shoe might be inside the house? That might be a reasonable assumption?
I never saw Mr. O'Keefe. I wasn't aware that he
because you didn't
have
seek
shoes
to find out the details. Other people knew every single fact that I just suggested at the time you walked in the house, correct?
Objection.
Sustained.
The fact is you didn't seek a search warrant.
I wouldn't. Correct.
The fact is you never searched the house.
That's correct.
The fact is you never searched the basement.
That's correct.
The fact is you never searched the garage.
That's correct.
And what, if any, information did you have related to specific evidence of a crime in relation to the interior of the residence at 34 Fairview Road?
I didn't have any. When thinking about residence and search warrants and evidence, I need to put the evidence inside the house. And so I don't believe that Mr. O'Keefe entered the home. So I had no nexus to the house.
And what, if any, evidence did you have that Mr. O'Keefe had ever entered the home at 34 Fairview Road on January 29th or on any other day?
I don't. On the contrary, I have evidence that he was outside, but I don't have anything putting him inside the residence.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions clearing Officer Farwell directly go to their credibility in our case, which again deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct. Nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects.
It's easy to throw out a name and attach it to the Birchmore case. Troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it. A factual basis, a good faith basis. We hear the defense say that Trooper Garino says, nothing to see here. I have not seen that report where Trooper Garino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Garino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor.
I think what we have here is not federal preemption.
Yeah.
It's the U.S. Attorney's Office stepping in where the District Attorney's Office failed completely.
Absolutely.
At the time of her death, Sandra Birchmore was a 23-year-old woman with her entire life ahead of her. And she was pregnant with her first child. We allege that Sandra Birchmore survived years of grooming, statutory, and then sexual violence, all at the hands of Matthew Farwell, who was employed throughout their relationship as an officer and then detective for the Stoughton Police Department. And when it became clear to Mr. Farwell that he could no longer control Sandra Birchmore, he allegedly silenced her permanently. This morning, Matthew Farwell was arrested on a federal grand jury indictment, charging him with 1 count of killing a witness or victim. Specifically, Mr. Farwell is charged with violating Title 18 United States Code 1512 for killing Sandra Birchmore with the intent of preventing her from communicating information about his possible commission of federal crimes.
And the crimes actually are different. The federal crime that Matthew Farwell is charged with is killing a witness.
Yeah.
It's related to the obstruction of justice statute. It's a way where my federal experience actually makes me uniquely situated to be the DA right now. And to charge to prove up the federal case, it's actually complicated because you have to prove that the intent underlying the murder was to cover up another crime. And I'm oversimplifying it. Fortunately, a couple of the best prosecutors I know are in the U.S. Attorney's Office handling that case, and a couple of the best federal agents I know are handling that case.
How did this all unfold? What happened here? Well, back in 2010, a 12-year-old Sandra Birchmore applied to join the Stoughton Police Department's Explorers Program, which introduces teens to policing. Officer Matthew Farwell was an instructor in that program. And as alleged in court documents, he befriended Sandra Birchmore, contacted her online, went to the library with her, became friends on Facebook, essentially groomed her. And then he committed statutory by having sex with her when he was a 27-year-old police officer and she was just 15 years old. Mr. Farwell continued to have a sexual relationship with Sandra Birchmore until her death 8 years later.
But the reality is, based on the evidence that is public in that case, there's evidence that Matthew Farwell murdered Sandra Birchmore.
Yeah.
And the murder case in the state is actually, it's a different case. You're asking about resources, and right now there's litigation in the federal criminal case. There's a pending motion to dismiss. There was a motion to change venue. And so there are resources being dedicated federally because the DA's office failed to charge murder. And I think the case raises questions about other state crimes. We're talking about a vulnerable young woman who admired members of law enforcement and who joined an Explorer program as a young teenager here in Stoughton, and who, by all public accounts, was taken advantage of by the officers she so admired. And what
Multiple of them.
What I haven't seen is any effort by the district attorney's office to investigate that and to bring those perpetrators, if in fact they committed crimes, to justice.
She found out that she was expecting a baby, and she told Mr. Farwell that he was the father. According to court documents, Ms. Birchmore was very excited about becoming a mother, buying baby clothes and other items, taking precautions to ensure the health of her new child. Sandra Birchmore had good friends, she had a good job, she had dreams of becoming a nurse, and she had a child on the way. But Mr. Farwell did not share in that excitement. It's alleged that Mr. Farwell reacted quite negatively to the news that Sandra Birchmore was pregnant with his child. And he acted angrily, it is alleged, when Sandra Birchmore started making requests of Mr. Farwell around doctor's appointments and ultrasounds and what information would be on the birth certificate. Mr. Farwell was losing control in late 2020, early 2021. And the information that Sandra Birchmore possessed about his illegal conduct was in danger of slipping out. In fact, word started to get out about their relationship. Less than 2 weeks before she was found dead, someone called the Stoughton Police Department and disclosed that Matthew Farwell had had a relationship with Sandra Birchmore. And when Mr. Farwell learned about that call, he became visibly angry. Mr. Farwell, it is alleged in these court papers, started to lose his patience, lose his temper, and the 6'4" Mr. Farwell started to be physically violent with 4'10" Sandra Birchmore. And Sandra Birchmore told her friends that Mr. Farwell had pushed her and shoved her and put her in a chokehold. She was scared. And during that same time, Mr. Farwell was allegedly planning Sandra Birchmore's murder. For the first time, he requested a key to her apartment. And she told friends that he was oddly inspecting the apartment and looking at the closet, including the closet that she was found dead in front of. And then it all came to a head on February 1st, 2021. Mr. Farwell went over to her apartment that evening, and he strangled Sandra Birchmore to death. That's the allegation in this case. And he used his knowledge and experience as a law enforcement officer to stage her death to look like a suicide. He allegedly attempted to cover his tracks to literally try and get away with murder. And he almost did, until today.
But the bottom line in a case like that is this: survivor and victim accountability, the DA's office's accountability to survivors and victims of crime is a key tenet of my leadership as DA, of the accountability agenda. And so one of the first things that I would want to do as DA is talk with members of Sandra Birchmore's family about how they feel. Because if there are crimes that haven't been investigated, if there are crimes that were committed that haven't been charged, they need to be investigated and they need to be charged.
Back in 2021, with the information that was available, Sandra Birchmore's death was ruled a suicide, or deemed a suicide. But over the last year or so, the FBI and our office have been working exhaustively with our state partners. We've uncovered critical new information, examined the existing information, all of which led to this federal grand jury indictment. If convicted on this charge, Mr. Farwell faces a minimum of life imprisonment. Giving voice to the voiceless, ensuring that no one is above the law, protecting the vulnerable people of Massachusetts, that's the highest calling of people in law enforcement. And this case represents those principles. And every day across Massachusetts, thousands of police officers, federal, state, local law enforcement, put their lives on the line to protect the people of Massachusetts. Mr. Farwell violated those principles, and now he faces very grave consequences. It is disheartening to have to charge law enforcement officers, especially with crimes as serious. But it's our job at the Department of Justice to investigate potential crimes without fear and without favor. We do in this office what we've been doing for decades with our federal partners like the FBI. We follow the facts, regardless of where they lead. We apply the law and the principles of federal prosecution, full stop. We are not influenced by social media chatter. We're not influenced by politics. We're influenced by the facts and the law. Our mission is to do our level best to do justice in every case. And our mission today is to do justice for Sandra Birchmore.
Do you feel that the circumstances of her essentially grooming speak in some way to the validity of programs like the one that she was enrolled in?
So, you're asking a broader question about the integrity of law enforcement. And I'll go back to, something that is important to me as a prosecutor, and that is people who choose to be prosecutors, people who choose to be police officers are oftentimes doing it, in fact, in most cases, for all of the right reasons. I think in Stoughton, in this example, we have one or more genuinely bad apples, and I think bad apple is too diplomatic a way to put it when we're talking about murder or grooming and worse. So I think it raises questions about how we ensure that people like that are never involved in Explorer programs again.
As the lovely Liza Little said, there are many parallels between these two cases, and they lead back to the district attorney, Michael Morrissey, who has a penchant for looking past evidence when it involves a cop, whether that be Brian Albert and his family at the Blizzard party, or Matthew Farwell. Remarkably, Morrissey has yet to issue state charges against Farwell. A recent filing by federal prosecutors in the Birchmore case revealed that Farwell's DNA was on the ligature used to kill Birchmore, and more disturbingly, there were bodily fluids, we'll say, in the undergarments of Sandra Birchmore when she was found dead, and they also matched Matthew Farwell. Also of note, it's been confirmed that Farwell was not the father of Sandra's unborn baby, which leaves us with a huge unanswered question, which is, who exactly is the father? We know Matthew was not the only one involved with Sandra from a young age. The three culprits we often hear talked about all the time are Matthew and his brother William, or Billy, and Robert Devine, who may be the most arrogant man I've ever seen on a witness stand. We will go over that testimony at some point if you haven't seen it. That dude is the personification of ick. There's also Joshua Heel, and a very interesting story that was broke by Michelle McPhee, who is a great reporter, which notes that a U.S. Army recruiter who was allegedly also involved with Sandra will be testifying for the prosecution against Matthew Farwell at his October trial. This election season is going to be wild to witness. Adam Deitch seems hell-bent on making something happen, specifically focusing on corruption in Norfolk County. But Greg Connor has put his name in the hat. He will be gathering support from all the people in Norfolk County who don't believe in science. We are going to be covering that race very closely. Couple of housekeeping notes. We had over 1,000 votes on our poll to determine the official name for Fervent supporters. As you can see, it was extremely close. Fervies came out with 41% of the vote, but it's not without controversy, as some people despise that name with a passion. So let's just leave it at this, guys. We don't need to have civil wars over a silly sand name. If you want to call yourself a Fervie, call it yourself a Fervie. If you want to be a Fervinator, be a Fervinator. Or if you just want to be known as a fan of Fervent, and FOF maybe, that's fine too. You know what, I think we're too cool for a name anyway. The Kelsey Fitzsimmons video got up to number 25 on the hype chart, which is insane. Thank you to everyone who hyped that video, and you can still do so today. So if you haven't, go over there, see if we can crack the top 20. Here's a new segment for Saturday shows. It's Comment of the Week, and it goes to Cindy Boxer 1184, who says, question, hey, what kind of music do you like? Answer, parody songs based on specific trials in Massachusetts. Well done, Cindy. You get 100 Fervent points. Maybe we can make this a real thing and have a leaderboard and a prize for our year-end winner. All right, guys, enjoy your weekend. Stick around in the chat, though. We're playing 4 songs in our outro today. But like, but comment, but subscribe.
It's a beautiful Christmas day, but for some reason I'm feeling gray. My wife asks me if everything's okay. I say it feels like my last Christmas as DA. I wonder how I'll fill my days when there's nobody left to frame. She tells me, pick your 3 chins up, it'll be okay. Make the most of what's left of your reign. You're right. If you laugh at my fat ass sliding down the chimney, that's witness intimidation, and you are guilty. Wanna know what happens when you litter? Don't ask me, ask Rich Schiffer. Wanna expose my favorite family? Just take a look at Aiden Carney. I made sure there was no justice for John O'Keefe. We'll prosecute Farwell, he was such a peach. Too bad, feds, you couldn't catch me. I'll continue haunting Norfolk County. Wait, who the fuck is this guy? I take it back, feds, you're doing great, guys. Appears my reign of terror is coming to an end. Took me this long to comprehend that I was involved in so many setups, but it was me who was the punchline.
chose me. Let's all get our stories straight. It's Thanksgiving Day the McAlbert way. Her name is Jen. Ooh, hey there, Jen. When she hears the ice cream truck, she runs. Run away, Ken. She calls Carrie. Carrie's a talker. To see if they came her way. Now here comes Nicole. Hey, Nicole. That's Jen's sister. She likes to clean her house. She's so tidy, but has the face of Irish poverty. Those are my words. How's long to roast a turkey? How's long till they depose me? Let's all get our stories straight. It's Thanksgiving Day the McAlbert way. And here comes Brian. Uh-oh, that's Nicole's husband. Poor thing, he's got a real bad temper. She's scared, but she loves him. 'Cause he can make calls with his ass. And there's Higgy. Hey there, Higgy. Another guy who makes calls with his ass. So neat. He's got a pocket full of SIM cards. He's headed to the junkyard. Open up your wallets this holiday. Make sure that the McAlberts get paid. What a cost to put your money toward them people who have no remorse. It's a McAlbert third party, and we party hardy. It's a McAlbert third party, and we party hardy. Oh yeah. And then there's Matt. But who cares about Matt?
I would listen to Adele while I threaten you. Ain't a bigger banger than someone like you.
Damn, Fervent, you make me wanna pull up, bitch.
Yeah, I run the streets, I mean run to the police. Don't believe me, why don't you come to D&E? Yeah, I'll bring you pizza just the way you like. I want you though, I tend to slip on ice. If you got a problem, say it to my face. We can throw 'em up and yell bang bang. Ask me about my car, I don't recall. Ask me about my text, I don't recall. Ask me about Ali, I don't recall. But if you ask me when I left, I damn sure recall. Ask me about my car, I don't recall. Ask me about my text, I don't recall. Ask me about Ali, I don't recall. But if you ask me when I left, I damn sure recall. It was 12:10, yeah, I know that to the dot. Went up to my parents' room, told them I love them a lot. Name on no police reports, how will I get caught? Damn, Steven Scanlon blew up my spot. Never been in a fight, okay, that was a lie. I provided screenshots as my alibi. What is metadata? I don't know. Those screenshots are real, just trust me, bro. Ask me about my car, I don't recall. Ask me about my text, I don't recall. Ask me about Ali, I don't recall. But if you ask me when I left, I damn sure recall. Ask me about my car, I don't recall. Ask me about my text, I don't recall. Ask me about Ali, I don't recall. But if you ask me when I left, I damn sure recall.
Fucking bleed before I hit the shit. Before I run your shit. Before I fucking chug a beer and hit that shit.